Good day everyone. I'm Angela, the moderator for this webinar. I welcome everyone for today's webinar, HIPAA and the new rules regarding reproductive healthcare. I would now like to introduce our presenter for today, Mark R. Bengelmans. Mark holds bachelor's and master's degree in philosophy from Emory University and Juris Doctorate from the University of Kentucky. I would now like to hand over the floor to the speaker. Over to you, Mark.
Thank you, Angela. We're going to cover basics of HIPAA privacy and introduction to the law enforcement exceptions for HIPAA privacy, which this new federal rule totally dovetails into. We'll talk about state authority of licensure board and agencies to exploit HIPAA exceptions against healthcare practitioners regarding abortion and reproductive health records. We will detail applicable implementation dates you need to know. We will review the change in definitions, which broadened and created more definitive confidentiality and protections for reproductive health records, including abortion. We will discuss the general prohibition and the applicable rule of applicability. Did I just say that? The required rule of applicability and how it raises presumptions and ask whether they are rebuttable presumptions or not. We will review the attestations required by the new law, an update to notices of privacy practices, and we will discuss how this dovetails into the disclosures for law enforcement purposes, how this changes everything. So remember the federal right of privacy that HIPAA started. Before that and existing thereafter are state law privacy rights. This webinar will cover and start with some basic HIPAA privacy requirements, and then we'll divert to initiate an introduction to review the law enforcement exceptions that allow state civil agencies to investigate with criminal prosecutors and criminal prosecutors to exploit HIPAA rules for various law enforcement purposes to obtain medical records of abortion. So in a post-Roe versus Wade healthcare world, it's now been 2 years, all you healthcare practitioners must understand how HIPAA privacy applies to your medical records of abortion as well as anything involving reproductive health care. HIPAA was effective, applied to healthcare providers who submitted requests for payment electronically. It basically applies to everybody in healthcare. There are many law enforcement exceptions to obtain records for law enforcement purposes, including court orders, court-ordered warrants, subpoenas, and administrative requests, administrative subpoenas for state agencies involved in investigation. So the HIPAA exceptions for law enforcement come under the uses and disclosures of PHI for which an authorization or opportunity to agree or to object is not required. There are still some restrictions. So these are different than general public health exceptions, and you will see that in the new definitions for the HIPAA law. There are just many exceptions that law enforcement has. There are permitted disclosures for health oversight activities as authorized by law. That's state law, including audits. You have to comply with a law enforcement court order or warrant, subpoena or summons, a grand jury subpoena, an administrative request, including an administrative subpoena or summons. State authority is plenary of licensure boards and agencies to use the healthcare law enforcement exception, and it's important here because physicians and nurses will be targeted. State licensure boards regularly investigate standard of care that involves by necessity patient medical records and protected health information. So it's been 2 years now since the Dobbs case came down, and remember that this was a case that upheld a Mississippi law banning abortion after 15 weeks of gestation. The vote was 6-3 to uphold the law. It expressly overruled Roe v. Wade. How abortion laws may be enforced, ABC News had a story about this. The law can apply to anyone, like somebody's mother who gives them a phone number for an abortion provider, or your best friend who drives you to a clinic. So a successful plaintiff could show a physician performed an illegal abortion, probably require medical records to be obtained, and a private party can obtain someone's medical record if they get a court order. National Public Radio had a story about this. HIPAA applies mainly to healthcare providers who are defined by law as covered entities. It doesn't apply to the persons who have information. NBC News talks about law enforcement involvement opening the door to obtaining non-HIPAA protected information. There are Fourth Amendment search and seizure protections under these requiring probable cause and a search warrant approved by a judge. Google vows to delete abortion trip data in wake of Dobbs. The White House came out about this. This was reported in CNN, constitutional standards and the woman's right to choose. It's been a sea change in the law where the U.S. Supreme Court's nullification of the constitutional right to abortion ushered in a transformative changes for healthcare attorneys. So remember, HIPAA does not apply to entities, businesses, or people outside of healthcare that might have access to persons' medical information. Applicable implementation dates you need to know about this new law. We've done all this setup for the disasters of why it was needed. The 2-year-old Supreme Court case that overturned 50 years nearly of precedent. The new law was published April 26th, issued the 22nd. The effective date has just passed us June 25th, and the compliance date is December 23, 2024, which is the date that persons subject to the new federal regulation. It's a change in definition where public health, as used in the terms public health surveillance, investigation, intervention, means population, not individual, population level activities to prevent disease and promote the health of populations, including identifying, monitoring, preventing, or mitigating ongoing or prospective threats to the health or safety of the population, which can involve the collection of protected health information. And reproductive health care is not just about abortion. It means health care that affects the health of an individual in all matters relating to the reproductive system. So in sum, the new rule prohibits the use of disclosure of protected health information in any of the following activities. 1, to conduct a criminal, civil, or administrative investigation, covers all those bases. Also, the second part of the rule is it prohibits the use of disclosure of PHI to identify any person for the purpose of conducting such investigation or imposing liability. The prohibition in the new federal law applies where the relevant activity is in connection with any person seeking, obtaining, or providing, facilitating reproductive health care, and the regulated entity that received the request has reasonably determined that one of the more following conditions exists. So the presumptions that are made, whether they are rebuttable or not, reproductive health care provided by a person other than regulated entity that receives a request is presumed lawful unless the regulated entity has any of the following. My comment about the attestations that are required that cover all this, to cover all the bases, that this is not just more paperwork, but sufficient documentation and compliance with the law that protect you. So do it and do it right. The update to notice of privacy practices is that covered entities are required to update their notices to reflect changes in the HIPAA privacy rule as well as the Part 2 regulation. That's from separate rulemaking. How this changes everything for law enforcement, disclosure for law enforcement purposes. So HIPAA and the new rules, you have to ask, it ain't been around that long, have the courts weighed in? Health and Human Services has said, quote, the Supreme Court's overturning of Roe has changed the legal landscape. The changing legal landscape increases the likelihood that individuals' PHI may be disclosed in ways that cause harm to the interest that HIPAA seeks to protect. The new rule prohibits the use of PHI, keeps information safe, and ensures people have access to high-quality health care. Top takeaways, protecting the privacy of patient health information is essential. So those are the top takeaways. Thank you, Angela, and thank you, conference panel. This was a good and productive use of our time together. Bye-bye.
Thank you, Mark. This concludes the session for today. Thank you everyone for participating. You may all disconnect now. Have a great day.